A protective order is a court order obtained by one person seeking protection from another. Three types of protective orders exist in the state of Illinois. The first is a domestic violence order of protection. This order of protection can be filed if the person you are seeking protection against is a family or household member. This includes those who are related by blood or by current or former marriage, share or shared a common home, have or allegedly have a child in common, are in or have been in a dating relationship, or are high-risk adults with disabilities abused by a family member or a caregiver. The second type is a civil no-contact order. A civil no-contact order provides protection for victims of non-consensual sexual conduct or sexual penetration. A civil no-contact order can protect the victim, family, or household members of the victim, and rape crisis center employees. Finally, the third type of protective order is a stalking no-contact order. A stalking no-contact order provides protection for any person who is the victim of a course of conduct that causes the victim to fear for his or her safety or the safety of another person, or to suffer emotional distress. If you would like more information about these protective orders and the remedies they can provide, you can visit illinoislegalaid.org or speak with an advocate. If a person violates an order of protection, civil no-contact order, or a stalking no-contact order, they have committed a crime and may be arrested. In order for a person to obtain an order of protection, civil no-contact order, or a stalking no-contact order, they must file a petition to request the order and appear in front of a judge. The judge decides whether or not to grant the request for the protective order. A no-contact order is not the same as an order of protection, civil no-contact order, or stalking no-contact order. A no-contact order is often entered in connection with a domestic violence-related criminal matter as a condition of sentencing or a condition of bond. A no-contact order can only be removed or changed by the judge overseeing the domestic violence criminal case. No-contact orders do not include the same type of relief as an order of protection, and the penalties for violating a no-contact order may differ from the penalties related to violating an order of protection. No-contact orders may limit contacts such as in-person, phone calls, text messages, social media, mail, and/or a third party. If you are a victim in a criminal case where a no-contact order has been issued, you may be asked to testify in court if the defendant asks to have this condition removed. If the order is removed, the judge will prepare a court order stating the no-contact order is no longer in effect. Protective orders, such as an order of protection, and no-contact orders can include different protections, consequences for violations, and can trigger different responses from the court. It is possible to request a protective order even if a no-contact order is already in place to access those remedies. If you want to learn more about the differences between protective orders and no-contact orders, please seek assistance from an advocate. Once you have received your order of protection, you may decide that you want to modify or remove it. Any changes to your order require the approval of a judge and a new court order outlining the charges. In order to seek a modification of a protective order, you must first file a motion to modify through the circuit clerk's office. A motion to modify could be filed to change items on your order of protection, such as the petitioner's protected home address, the petitioner's protected work address, children visitation, extend the order of protection terms, vacate remedies, and other potential changes that are not listed. A court appearance will be required to seek approval of the motion by the judge. Similarly, you may be able to vacate or terminate an order of protection by filing a motion to vacate through the circuit clerk's office. When an order of protection is vacated, all remedies outlined within the order are also terminated and can no longer be enforced by the law. This includes remedies such as prohibition of contact, parenting time and custody, child support payments, ownership of residence, mandatory counseling for your abuser, possession or protection of personal property, and other remedies that may have been specifically outlined within your order of protection. A court appearance will also be required so that the judge may review and potentially approve the motion. With the filing of either a motion to modify or a motion to terminate a protective order, there are requirements of you to give notice of the filing to all parties on the case. Anyone who feels they may be in danger because of another individual may wish to create a safety plan. Safety plans can help increase safety by preparing in advance for the possibility of violence. Even though you cannot control other people's choices to use violence, there are steps you may take to ensure you are responding in the best way possible to potential violence. Prior to changing or vacating an order, the court may ask you if you have considered the impact this change may have on your safety and if you have been forced or coerced into changing or vacating your order. You may wish to speak with an advocate to explore this further. When terminating a protective order, all of the remedies that were enforced by the order will no longer be in place. If you have a safety plan in place, you may need to update your safety plan so that it accurately reflects these changes. If you are uncertain about modifying a protective order, terminating a protective order, or making a safety plan, please reach out to an advocate. Advocates are provided by the county at no cost to you and offer various resources to victims of domestic violence. They are located in the Winnebago County Courthouse on the 3rd floor in the Domestic Violence Assistance Center. The Family Peace Center, located at 315 North Main Street in Rockford, Illinois, can also provide help with advocacy and discussing your options as a victim of domestic violence. The Family Peace Center takes walk-ins or appointments and can be reached at 779-348-7600. Please inform the court if you feel that you need additional time to speak with an advocate.